Ellis and Cage are on the same case.
Okay. They're both there too. This is Claudia. Yes, ma'am.
Good morning.
morning.
Good morning, Your Honor.
We're waiting for the court reporter.
All right.
He was sleeping.
Morning, Miss Alice. How are you?
Good morning. How are y'all?
Great. Good to see you.
He's looking for me. Right here. You're not on here yet. Let's see. Oh. There you are. I don't even know why we let you on. It just kicks you off after a while anyway. All right, this was set for a jury trial next week, I believe. Is that right?
Yes, sir.
It's 003-2156-2019, Becky Bennett versus England, two Englands. Okay. Obviously, we're not doing jury trials right now, so we can reset it to, it's probably going to be April. Hopefully by March, we're going to start doing jury trials here. That's really the only option right now, because we're just, if we get a jury panel up here right now, the district courts are taking them for felony trials. So it's just the way we are right now. So I don't know what else to tell you other than that. That's probably the earliest we'll get to try it is April. So
Okay.
do you want the new setting in April or?
I am booking up out there in April. So what is your availability? Like what
In
days
April?
are you?
The
Yes,
only,
sir.
the week of April 19th is our civil week here.
Okay.
We book 1 week a month for civil stuff and give it priority over the criminal stuff.
I can do the week of April 19th.
Okay.
Same.
Does that work? Okay.
Yes, sir.
Let's set y'all for April 19th. You know, obviously there's gonna be a whole bunch of civil stuff moved to that date. It goes by which one's the oldest. So we'll see where y'all are. The pre-trial is gonna be on April 15th, the Thursday before at 10 o'clock, same thing. And on that day, we'll line up the cases for the following week. Hopefully what we're gonna try and do is set up these cases where we'll have a visiting judge come in and take care of all of our pleas and other stuff, so we can try several cases that week. So maybe we can get y'all tried the week of April 19th.
Okay.
All right.
Sounds good.
This is the only notice you'll get. So your case will be set for the week of April 19th with pretrial on April 15th. All right.
All right.
We will
Thank you all.
see y'all then.
Thank you
All
all.
right.
Have a
Thank
good
you.
one.
Thanks. Bye-bye.
And the other one's Bergenholtz.
In the card. But I've never heard anything from her, so she doesn't have a Zoom invite
Okay.
from me.
You ever heard from her? You're muted.
Good morning, Your Honor.
How are you?
Just want to thank you and yourself today, sir.
I'm good. This is 003-567-2020 Stephen Bergenholtz versus Saida Bakari. We never heard from her, so she's not been invited to this session. Anyway, it's set for trial next week. Did you want to try it next week?
Your Honor, for clarity purposes, I filed a motion to enter default judgment and request for a hearing that was set for today. pursuant to your order dated September 1st, 2020, that was entitled Order in Part Granting Plaintiff's Motion for Terminating Sanctions and Costs. And I communicated with the court staff about this as well. In fact, they told me to set it for today when I asked for an earlier hearing date. They told me to leave it for today.
She filed an answer. Did you file a motion to strike her answer?
Yeah, Your Honor, yes, I filed a plaintiff's motion to enter default judgment and request for a hearing.
That's not a motion. That's not a motion to strike.
Yes, Your Honor, you had already ruled on that, Your Honor, on September 1st, 2020.
No, what I had ruled on was that if she did not comply with the order, I would strike her answer. And so you have to set it for a motion to strike where she's given an opportunity to explain why she did not comply if she didn't comply. You haven't filed a motion to strike?
Yes, Your Honor, and that's what yes, Your Honor, that's what my motion to enter default judgment is based on, is requesting the court to strike her answer. And that was filed November 3rd, 2020, and served on her via certified receipt mail. And again, that was pursuant to your September 1st order, which I included on that motion.
I'm trying to find
And
it.
it made part. And your staff had indicated they were going to set it for today, though I did ask for an earlier hearing. They said to leave it for today.
Let me see what we got.
If you look at number 10, it says plaintiff requests the court pursuant to its September 1st, 2020 order that the court strike defendant's pleadings and answers in this case and render a judgment. And it sets forth the basis for such as well in number 10.
Have you sent her all this?
Yes, Your Honor, I sent it both regular mail. I sent her all my recent filings by regular mail, and then this I sent by certified return receipt mail, Your Honor.
Did you file an order
Yes, I did, Your Honor.
striking her? I mean, I can't give you a full default judgment because you have unliquidated damages. We'd have to have a hearing on the damages.
Yes, Your Honor, that's what I understood today was going to happen today, per your staff. When I asked them to set it again, there was a notice of hearing properly set, filed and served. I'm setting it for today, and I came prepared to argue the damages, etc.
Filed, they were filed, there were no actual orders filed for the default judgment either.
Yeah, I need to get an order from you. And then, because you didn't file the
You need what?
order.
I couldn't hear.
separate-
Sorry.
I need orders from you that are separate from what you filed them as exhibits. So I need separate orders so I can sign the
Yes, Your Honor, and
order
I filed a.
granting a default judgment.
Yes, Your. Yes, Your
And
Honor,
then,
I filed a final default judgment, subject to the amounts, and my arguing, or presenting the, evidence for the amounts, et cetera, as you just mentioned. So yes, I could fill in the dates and the amounts, if I could proceed, Your Honor. But I did provide a final default judgment, proposed order, minus the dates and the amounts.
Okay, well, I see where you filed an affidavit supporting your damages. I am going to strike her answer. I am going to grant the default judgment in the amounts that you've listed here. But I need an order, just send the order in with, some blanks in it, and I'll fill in the amounts that you're gonna be awarded.
Yes, Your Honor.
I'll base it on your affidavits.
Yes, Your Honor. The affidavit, though, doesn't go into to the extent of the damages. Per my understanding, that was for the, well, I list there $80,000 for pain, suffering, and the various other things I pled in my original petition. But for clarity purposes, would Your Honor allow me not more than 5-10 minutes at the most to put this on the record in case there was a dispute to come later on?
Yeah, you can offer whatever you wish to offer.
I'd appreciate, Your Honor. Thank you. Your Honor, to begin with, I filed the exhibits for this hearing on November 6th. What I marked as Exhibit 1, plaintiff's second request for admissions to defendant Zahida Bukhari, which requests for admissions are dated July 20th, 2020, which defendant needs to respond to. Exhibit 2, plaintiff's motion to enter default judgment, along with the attached exhibits to it dated November 3rd. Exhibit 3, plaintiff's affidavit in support of entry of default judgment, dated November 4th, 2020. Your Honor, these exhibits are my evidence that I'm offering to evidence. I don't hear an objection, so I'd like a reference on the record that they are admitted.
All those can be admitted and considered.
Yes.
Anything else?
Yes, I also request the court to take judicial notice of the case terminating sanction order entered in on September 1st, 2020, which order required defendant to, amongst other things, fully respond to certain of plaintiff's discovery and to provide a date certain to take the defendant's deposition. And if defendant, and I quote from your order, Your Honor, fails to comply with the court's order on or before September 15, 2020, that defendant Zahida Bukhari's pleadings and answer in this case will be deemed stricken out of this court and will render a default judgment against defendant. And at this time, I'd ask the court to take judicial notice of the case filings and the. Is that granted, Your Honor?
Yeah, I've taken judicial notice of everything I've signed.
Thank you. In addition, Your Honor, defendant failed to refuse to respond to plaintiff's second request for admissions as of date. These were properly served on her then attorney on July 20th, 2020, and due back on or before August 19th, 2020. Defendant's refusal to respond to make responses are deemed judicial admissions, and they establish that defendant injured plaintiff. Defendant did not have plaintiff's consent to strike him. That defendant made physical contact with plaintiff. That defendant admitted, defendant told the Dallas arresting police officer on January 7th, 2019, that defendant hit plaintiff, that plaintiff suffered bodily harm because of defendant's acts, and that defendant admitted defendant knows the difference between right and wrong. And for matter of clarity, when a party fails to answer requests for admissions or untimely responds, the matters therein are deemed admitted without the necessity of a court order, and such admissions are conclusively established as to the party making the admissions pursuant to Texas Rules of Civil Procedure 198.2A and Texas Rules of Civil Procedure 198.3, also pursuant to the case law in Marshall versus Vice 767 Southwest 2nd 699 700, a Texas Supreme Court case from 1989. Moreover, the admission, once deemed as a judicial admission, it may not be contradicted by any evidence, whether in the form of live testimony or summary judgment, pursuant to Marshall 767 Southwest 2nd at 700. And then there's also Gotch versus Gotch, a Texas appellate case.
It's all deemed admitted. I understand that.
Okay. Thank you, Your Honor. Plaintiff filed, just to summarize the issues here, I filed a case on February 24th, 2020, based on my being assaulted, my being injured, pain, suffering, amongst other issues. Just to speed through this, Your Honor, plaintiff myself has had a great amount of pain to my eyes that results resulted from the injury. The concussion still has lingering effects, including fatigue and headaches on me, and my neck, well, far better than what it was, periodically hurt as was aggravated by the sustained
You're cutting out.
beats to my back and other body. Slow down.
You're cutting out.
Sorry, Your Honor. From the assault, I was taken by ambulance to the hospital, and I was diagnosed as concussion, eye pain, neck sprain, and back and pain to my upper back. The assault was unpropitious. Defendant does not dispute the facts, and defendant admits she informed the police she made physical contact with myself and that she hit plaintiff and she caused the plaintiff harm. While the police were investigating the facts just after the assault, they located both illegal drugs and alcohol in possession of the defendant. The defendant was arrested at the scene and taken to jail. The defendant was charged in Collin County with assaulting me in case number 005-81955-2019. And separately, defendant was charged with being in possession of illegal drugs, primarily cocaine, in Collin County in cause number 416-83326-2019. My medical expenses you already reviewed pursuant to the affidavit. So I won't consume the court's time. In the petition, I made a claim for assault and battery, and exemplary damages were requested, but the focus on the damages here, the liability. As a direct and proximate result of defendant assaulting myself, I made the basis of the lawsuit. Plaintiff was caused to suffer bodily injury and to incur the following expenses, which are summarized in the affidavit as well. And then the reasonable medical care and expenses. In addition to that, reasonable and necessary medical care and expenses for the future. I was seeking $8,000 physical pain and suffering in the past, $20,000 physical pain and suffering in the future, $15,000 physical impairment in the past, $5,000 physical impairment, which in all reason probably will suffer in the future, $5,000, and mental anguish as a result of the injuries and the assault in the past, $15,000. These amounts are reasonable before the court considers if it was to consider exemplary damages. And then in Sharm Inc. versus Martinez, 900 Southwest 2D 777 and 786. The appeals court affirmed default judgment as to liability, affirming award of $400,000 for pain and suffering and physical impairment. The evidence is uncontroverted, therefore, as the plaintiff, I'm requesting the court to grant me a default judgment, which it has already acknowledged it will and has, in the amount of $92,901.12. This amount is inclusive of filing fees of $306, process service of $100, deposition that I previously apprised the court and made a filing that defendant refused to attend after proper notice and appearance, $150 in postage costs. Though they exceed $18, I was asking the court for $15. I provided the court a final judgment order for the date prior to today. And unless the court determines it requires additional facts or evidence, additional argument or testimony, I rest my case on it.
What I need from you is an order with all the amounts you've sought blank. I'll fill them in. I'm going to take it under advisement and I'll make a judgment and make an award to you at some point in the next couple of days. But the order that you sent as an attachment. We need a separate clean order filed into the case. Okay.
Yes, sure. And I'll send the date. I'll fill in the date. The
And just
hearing,
leave it blank for every category of damages.
and then, Your Honor, I was also asking that
You're breaking up again.
Your Honor, you went silent. I apologize. I couldn't hear you.
Your whatever you just
I
said.
couldn't hear what you said, Your Honor. I'll
Yeah,
leave. In number 11 of the order, Your Honor, I'm asking the court to also order that the defendant has 30 days to satisfy the order, not later than December 15th, 2020. And I'll fill in those dates as well.
That's not part of the order. I mean, the judgment becomes final after 30 days. She can appeal it if she wants to, those types of things. But I can't order her to satisfy the judgment.
Right.
You'll have remedies if she doesn't.
Okay.
All right. Let's send the order
Okay,
in. I'll get
I'll,
it signed and we'll be done. All right.
Have a great day. I appreciate it.
You too. See you later.